Counsel. Next case is Seminole Entertainment, Inc. versus City of Castleberry. Morning, Mr. Mason and Mr. Brown. You want to reserve any time?
I'd like to reserve 2 minutes for rebuttal.
Two?
Two.
Okay.
Good morning, Judge Griffin. Good morning, Judge Boyce. Good morning, Judge Cohen. I would like to address the merits of this case in the body of my discussion, unless you direct me otherwise on the procedural issues. And I want to start by re-emphasizing that if you're going to take away someone's license, that's considered a punitive act under the law, and a license is considered a property right, and therefore there's a whole panoply of rights that you're entitled to in this case, because it's a license which governs striptease dancing. It's governed under both the Due Process Clause of the United States Constitution as well as the First and 14th Amendments. And what I want to point out is that their code is extremely clever in this sense. It's very cleverly written. And they're able, when you ask for a license in the city of Castleberry to offer striptease, erotic dancing, you have to list all your employees, your workers on the application. And if any of those workers commit a crime, and they specify those specific crimes in their code, then the knowledge of the crime committed by the employee is automatically imputed to you, the license holder, the owner, whatever term of art you want to use to address the person who actually owns the business, in this case a corporation with stockholders. Second is their definition of licensee is so broad that it includes operators. And if you actually look at the revocation order, they say that in several places just to illustrate what I'm telling you is actually beyond the facial black letter words in the code. It's illustrated by their brief. They concede that. Judge Nelson agreed with that. She said there'd be very few instances where if an employee committed a crime on your property that wasn't going to be imputed to you. But in this case, anyone who works at the business is a licensee because they're an operator. In fact, a couple doormen committed crimes or purportedly committed crimes, and that was imputed to the ownership. So if we start with that premise, the question is whether or not that violates the United States Constitution, because that's what we raised.
Counsel, I don't speak for my two colleagues, but I understand your argument on the Constitution, but I'm concerned about how you get to that point and whether res judicata and law of the case bar you from even raising that argument at this point. Could you address that issue, please?
Yes, I'll start with the res judicata. Judge Griffin wrote that opinion, 866 Southern 2nd, and in there, and to use Mr. Brown's words, she was highly specific and technical regarding the comparison of the two actions, the certiorari action compared to the deck action, the original action. And she, on behalf of the court, came back and said there are certain paragraphs that are in the deck action, the constitutional action, that are not in the fact-specific cert action. And what we did is we simply went back and we amended our lawsuit. We took those exact same claims, which were O'Brien claims, but they were brought under the Florida Constitution, and we reconfigured them as U.S. constitutional questions. But other than that, the language is identical, and this court already found that they were alive and well. So when you...
Mr. Mason, are you familiar with the Don Suntan Corp. versus Tanning Research Laboratories case?
No.
Well, what that case basically says, it's a case out of our court, and what that case says is that when you have a lawsuit and it goes up on appeal, if you want after remand to amend your claims, you've got to get the appellate court to agree. That only the appellate court can give you the right to go back and restart your lawsuit on remand.
Well, how? I don't understand the logic of that, but obviously I haven't read.
Well, I think the logic has to do with res judicata and law of the case. You've had your shot. You've had your chance to raise your claims. You've come up on appeal. You've made your argument. We've told you which one survived. And if you want to go back and start over, then you've got to get the appellate court to agree to that. Otherwise, you're limited to that which this court said survived. And that makes sense to me.
Let me address in a couple parts. One is I'm not familiar with the case, therefore, just as a matter of fairness, I'd like to be able to file a supplemental paper or brief on that. Two, there's nothing in the appellate rules or the rules of civil procedure that state that. But even if we move past that, the question in this case is we did move to amend. And when you read the amendment transcript, we cited a body of law. I mean, I went to great pains. I bet I cited somewhere between 6 and 10 5TCA cases to Judge Nelson because I was concerned they wouldn't allow the amendment. I mean, I banged on those cases again and again and again, probably for 15 or 20 minutes. And Mr. Brown was against them. And this court had said time and time again, cases out of Seminole County and Orange County from the 5th District, that the law of amendment of a complaint is extremely liberal. In fact, you have reversed cases where people came up on the day of summary judgment and said, by the way, you know, the hearing's been set, the motion's been filed, everything's been responded to, and the judge wouldn't allow the amendment. And they came back to the 5TCA and they said, you know what, he's entitled to amend because we want to address the merits of the claims. So in this case, we have a judge who grants the amendment. I mean, is there any doubt in anyone's mind that if I would ask you to amend that you wouldn't have granted that?
Well, the problem, Mr. Mason, is that as I read the transcript on the motion for leave to amend, Judge Nelson accepted your argument entirely. You argued basic amendment law to her, and she accepted it and said, all right, you're right, you've got a right to amend, and then I look at res judicata in law of the case. Question is what Judge Nelson would have done if you had brought the Dunn-Suntan case to her attention.
I don't know.
Based on my reading of the case, I don't see how she could have done anything other than say, Mr. Mason, you've got Florida state constitutional claims, and that's all you got. That's all that's left in this lawsuit.
Well, even if that's all we had left, that's what we raised before her. We just reconfigured the exact same claim in terms of the United States Constitution. You know, just as a matter of basic fairness, to cut the legs out beneath Rachel's on that issue, which was never raised or litigated in front of the trial judge, where the trial judge granted us leave to amend. I mean, there's something fundamentally at odds with fairness that a judge can give you leave, sign an order, put her John Henry on it, and say, we're going to allow you to amend your complaint. And then all of a sudden everyone says, aha, you know, you made a mistake. We allowed you to amend. We shouldn't allow you to amend. And now you lose everything and your client's just out the door. I mean, that certainly, I mean, that could not have been contemplated when you issued this Don-Sun case. It doesn't make any practical sense in terms of what you've said in all your amendment cases. In all your amendment cases, you repeat the refrain again and again. We want to address merits. We're not concerned with procedural issues. Unless there's some manifest prejudice, we want these cases amended so that we can get to the heart of the matter. And so I don't, that seems to me to be a contrary position, at least factually specific in this case about what happened. I mean, who would have ever contemplated that we would have got a reversal? We come back, we move to amend, the judge grants the leave, and then all of a sudden we come back to the appellate court, and the appellate court says she shouldn't have granted you leave to amend, even though there was no appeal from that, there was no interlocutory appeal, there was no cert action, there was nothing. I mean, I haven't read that case, but that just seems to me to be contradictory to the logic of that proposition.
Well, I mean, well, then take it to the question of the law of the case. I mean, that's really all this is an application of law of the case. You make your claims, you go up on appeal, we tell you which ones survive, you go back and you deal with those ones that survive. You don't get to keep going back and forth and raising new claims. You made the decision to make the claims. Surely the federal Constitution was not something that did not pop into your head before you came to the court on appeal the first time. You had the opportunity, an absolute opportunity, to raise your federal claims, and you made the decision, for whatever reason, not to raise them. So you come up here, we tell you which ones survive, you can't go back without the appellate court telling you so, and raising all these new claims. That's what this is about. And I think you know that.
No, I don't know that. If I would have known that, obviously, I wouldn't do that intentionally, knowing that later on, I'm going to end up bleeding. I mean, I would make a more intelligent decision than that, presumably. Considering how hard we've litigated this case now for 4 or 5 years. And in this particular case, we simply did what Judge Presnell either stated or intimated to us, where he said, your case was kicked out on summary judgment. You could have raised all these claims in state court. We come up to the District Court of Appeal. District Court of Appeal reverses the case, and we come back and amend our case just as he suggested to raise anything and everything we wanted to raise under the U.S. Constitution. But if you look at 866 Southern 2nd, the case regarding whether or not there was O'Brien, whether it meets the O'Brien test, whether there's a substantial governmental interest, and whether there's a least restrictive means in doing that, meaning, and in this particular case, these First Amendment cases say the obvious, that you cannot take someone's license away without knowledge. You cannot impute liability based upon the conduct of an employee. And that's the exact same case that you remanded. So, Judge Griffin, if you affirm this case on an alternative ground and you state, well, we did remand this on that issue, and he's right, it's the exact same issue, it's the same language, but it's just raised under the First Amendment rather than Article 1, Section 4 of the Florida Constitution. And Article 1, Section 4 is the First Amendment parallel under the Florida Constitution. He reconfigured it under the First Amendment. And even though the trial court gave him leave to amend, and even though this was never raised by anyone and raised for the first time in oral argument by anyone, I mean, that's just not fair. I mean, that's just not fair, especially when you say again and again and again, in all of those amendment cases, we want to address the merits. We want to determine whether or not these people were treated fairly or not, whether the law is up or down, but not on a procedural issue like that would just kill us. I'm telling you, if I would have known about that, I would have done a lot of.
So what you keep avoiding is the basic principles of law of the case, which is all this is. I mean, you talk about unfairness, but law of the case is an established doctrine. It's the basis on which the trial court ruled, and it's essentially the same thing that we're talking about. Why don't you explain to me then, if you're going to survive on this appeal, you have to explain to us why law of the case and res judicata do not bar your claim.
2 reasons. One is Giuliano from the Florida Supreme Court, which you concurred on. You wrote a concurrence post-Giuliano, Judge Griffin, and stated that unless the exact same issue was not only raised on appeal, but unless it was specifically addressed on the merits by the appellate court, law of the case never subsumes anything that was not specifically raised or specifically addressed on appeal. This simply doesn't fit within the confines of law of the case, because not only does it not fit, not only was it not raised or adjudicated, you reversed it and said that claim was alive and well. You can look at our amended complaint, look at our predecessor complaint. It's the identical language. I mean, it's just virtually the identical language.
We're not talking about a comparison of the cert case and the declaratory judgment case. We're talking about law of the case in the DEC action itself.
And what I'm saying is, these issues we've raised, you did not adjudicate against us. You reversed them for us, and therefore it doesn't fit within the 4 corners of law of the case. It simply is a misplaced doctrine that's trying to be blanketed on top of this particular case. It does not apply. There's nothing out there. They haven't cited anything that says that it applies. If we would have raised the case, the issues, and you would have adjudicated them against us, then absolutely we're barred from coming back and saying, hey, we want to adjudicate them again. But they were never adjudicated. When we had the oral argument before Judge Nelson, I practically begged her. You can read it on the paper. I said, Judge, out of all these cases, they've all been decided on procedure practically. Where is there a merits determination on the specific issues that we've brought before you? That's what we're pushing for so hard, because we're convinced we'll win on the merits. And she says, and I quote her in the record, you're right. None of these cases address the merits of your claims. She agreed to that there has been never a merits determination by anyone, a trial court, an appellate court, 0. So how can law of the case apply if no one's ever adjudicated the merits of the claims that we're here on this morning? So law of the case and res judicata don't apply. I mean, I was absolutely convinced walking in here, and hopefully I don't kick myself as I'm walking out, I was absolutely convinced that those were throwaway arguments, that they could not win on procedure in this case. They cannot keep winning on procedure, that we've got to have our day on the merits. That the court should say up or down whether or not you can take someone's business away from them by taking their license when you just impute liability based on the conduct of a doorman. I mean, that's just flat out wrong.
Counsel, if you were representing the city of Castleberry and you were asked to redraft that ordinance, what would you take out of the existing ordinance to make it constitutional?
I think that I would, and I've never been, to be honest with you, I've never been 100% clear on this, but I think that the beverage cases in Florida, going back to Justice Carroll in the 1930s and 40s, he says this eloquent language, "You're not your brother's keeper," and then for the next 50 years, Florida courts, in taking away the 7-Eleven's license to sell beer, says you either have to show that the owner was complicit, that he was participating or had knowledge of it, or two, the conduct is so close to him because there simply is no attempt to comply with the law. There's no supervision. There's no due diligence. There's nothing that would show that he would be a good steward from a reasonable man's standpoint. So I think I would track that language. Am I absolutely certain the courts are not going to say the First Amendment is entitled to a hyphen standard, because the courts have never specifically addressed that. They just strike them down when they don't have the knowledge. They don't come back and rewrite it and tell them what it is. But to answer your question, if I had to answer it, I think that's what I would track it. And I wouldn't use the licensee. In fact, by keeping that language on there, and I think probably maybe the reason they're doing it is because of this case, they need to get rid of that language, because you can't take someone's license away based on that. You're going to have these cases reversed in the future if you don't fix your code. So that's how I would fix it.
You've got 4 minutes left if you want to continue, or you can say reserve it.
I'll reserve it, Judge. Please support Usher Larry Brown for the City of Castleberry. Let me first point out what the ordinance in fact says. 1492 was the violation ordinance, and as you know, the Adult Entertainment Code was amended in 2003. The code that was at issue in December of 2000, when the quasi-judicial proceeding was taking place before the City Council, and in 2001, when the revocation went into effect in the end of January 2001. That code has been substantially changed as to the hearing process in 1493. Mr. Mason is challenging 1493 as well as 1492 as far as facial unconstitutionality. So it's important to recognize that there is a mootness argument, that he's not challenging facially the ordinance that exists now. Now, under 1493, attorneys who are employed by the city as hearing officers act as hearing officer. This is not a quasi-judicial proceeding before the City Council, and hopefully that will take away some of the concerns that the first panel had on the interlocutory appeal in Rachel's 1 in terms of how the hearings are conducted. That gets me to the next point. Mr. Mason kept saying that the claims in the first complaint before it was amended are the same verbatim. Actually, that's not true. In paragraph 30, I think that's substantially different. 30 deals with the procedures, the criteria as to how the hearings are to be conducted. It may be that he amended the complaint to remove that because he saw that we amended in 2003 the hearing procedures. I don't know that. But 30, paragraph 30 is substantially different. Moreover, Mr. Mason doesn't credit the difference, the real difference between a Florida court analyzing the United States Constitution versus the Florida Constitution, even though the provisions may be the same or similar, such as the freedom of expression, and even though the courts may look to the federal cases for guidance when interpreting the Florida Constitution, it's clear that the Florida courts have said that they're not necessarily bound. I mean, a good example of that is the recent case in Holmes versus Bush. The First District Court of Appeals struck down the voucher program on the grounds of violation of the Florida Constitution, establishment of religion provisions, and that, of course, involved financial aid to families who then in turn would use that financial aid in private schools. The Florida Supreme Court affirmed on different grounds, which were more solid, I think more sound. The Florida Supreme Court affirmed on the basis, they affirmed the first on the basis of uniformity, that you basically are creating two public educational systems, one of which has FCAT and accountability, one of which doesn't, and therefore you don't have the uniform system of public education required under Article 9 of the Florida Constitution. The point is,
if they had approached at the first DCA that Holmes-Bush case looking at First Amendment federal analysis, they would have said the voucher program presumably is constitutional, because there are many precedents where the federal courts have looked at public funding of private schools or public funding that inures to the benefit of private schools and have found that it doesn't necessarily violate First Amendment. A couple of examples of that are cases under the Individuals with Disabilities in Education Act, where they found that federal funds can provide benefits to disabled kids at private schools, and that doesn't violate the First Amendment. Kids can go to Notre Dame on federally guaranteed scholarships. It's religious colleges. So that's just one example that there's a real difference when he says he changed his complaint from one under the Florida Constitution to one under the United States Constitution. It's a huge difference. Moreover, he inserted for the first time in the amended complaint a claim for attorney's fees under 42 U.S.C. Section 1988. We weren't exposed to attorney's fees liability under the initial complaint. For the first time in count one of the amended complaint, he asked for damages under 42 U.S.C. Section 1983. So clearly, and I would say that damages request under Section 1983 is materially different to his paragraph 32 of the first complaint, which is if the revocation order constitutes a taking without just compensation. Were
those issues ever adjudicated prior to this amendment? That you're raising in the amended complaint, the issues that you've just discussed in the amended complaint, were they ever adjudicated prior to that?
I mean, in terms of damages requests, no. But
in terms of the court looking at them and ruling on them?
Yeah. I think they effectively were, and let me explain, and this maybe is a chance to take a second bite at the apple with Judge Griffin. I think in Rachel's 3, the case remanding this case, I probably just expressed my frustration. I didn't express the logic of why I was frustrated. Your Honors, when the law in Florida, as I understand it, is that when you are aggrieved by quasi-judicial action, you have a right of direct review, which if it's an administrative agency, it's 120.68 to the DCA, or if it's municipal quasi-judicial action, as here, petition for writ of cert to the circuit court, and then on for second-tier review, which, as you know, the second-tier review in our case was in favor of Rachel's. In favor of the city of Castleberry. Here is where the confusion is. Yes, these cases, starting with the Key Haven case, allow you to separately bring, if you choose, facial constitutional challenges directed against the subject ordinance or statute.
But if he amends his complaint and brings up those issues and they've never been adjudicated, how can res judicata apply?
And let me, that's what I was getting to, I guess not as succinctly as I should. Judge, what he did in this case and what frustrated me, and I don't think I explained it like this, and maybe the way this case goes, I'll have a chance to explain it better the next time around, but here's what he did. He did, in the cert case, get a substantive ruling on some facial challenges to the ordinance. Maybe not exactly the very same precisely word-crafted facial challenges at issue in this case. For example, he challenged 1492 and 1493 facially in the cert action. It's part of this court's record. He challenged it on the grounds of failure to provide for prompt judicial review. That's why we cited Boss Capital versus Castleberry in the cert case as well as this case. So he did raise, Your Honor, he did raise some facial challenges.
Some, but not all.
Some, but not all. And my point, Your Honor, I think if we go back and think, I think the proper rule is if you raise some, then all of your facial challenges are subsumed. You can't split your facial challenges as between the direct review.
Have you got any cases that support that argument?
Yes, Your Honor. The Key Haven case, the Florida, we didn't cite it in this case, but the court should be well aware of Key Haven and its progeny. Key Haven versus Board of Trustees, I think of Internal Improvement, it's some sort of environmental group agency of the state. That case, Florida Supreme Court from the 1980s, for the first time says that if you're aggrieved by agency action, you can challenge the facial constitutionality of the subject ordinance or rule or statute in the direct appeal, or you may challenge the facial constitutionality in a separate deck action, which is where we're here at today. Rachel's problem, I submit, is that they are attempting to split their theories as to the facial unconstitutionality of the ordinance, and that I don't think they can do. I think the Keyhaven case and the cases that cite it make it clear that you can't do both. You've got to pick one form, and I think that's why I was frustrated, and I think I used Mr. Mason liberally quoted me in some hearings in this matter where I was saying I couldn't believe how the Fifth basically wordsmithed and fly-specked, and you did a lot of labor in this court, and maybe I didn't explain the argument well enough that would have perhaps prevented you from doing that. I think with the infirmity...
You think what we should have said is because he raised constitutional claims in the cert action, he had no right to file a deck action on constitutional claims at all?
Yes, Your Honor, exactly. Limited to facial constitutional challenges, not as applied. The Keyhaven case makes it clear you can raise as applied constitutional arguments along with your other procedural arguments in the certiorari action or the direct review action, but purely facial challenges must be raised separately or with the direct challenge, and that's what I don't think they did here. They're attempting to split. If I could address some of the merits that Mr. Mason got into. 1492 is the violation section. That was not changed in the 2003 amendment. So to the extent there's an infirmity there, it's still there. But we submit there is no infirmity as a facial matter. And as this Court knows, to successfully challenge the facial constitutionality of an ordinance or statute, the general rule is you must show that in every application, it will be unconstitutional as applied. There is an exception for First Amendment challenges. In the U.S. Supreme Court case Broderick against Oklahoma, the First Amendment exception is that you have to show that there's a substantial risk that with, many of the applications it would be unconstitutional. Let's look at 1492. It's broken up into two parts, suspension and revocation. The suspension provisions say that if you get a certain number of violations, and of course the violations under the ordinance are limited to prostitution, drug dealing, violations of the beverage laws, essentially the kinds of crimes that go to the heart of what is permissible to regulate against under all of the cases which approve of these types of regulations, such as City of Renton, Young versus American Mini Theaters, the Barnes case, City of Erie versus Paps AM, on and on and on. It is permissible to recognize that even one of these types of facilities carries with it a substantial risk of adverse secondary effects, typically prostitution, typically drug dealing, typically diminution in property values, urban blight, things of that nature. These things are expressly recognized in the U.S. Supreme Court decisions. Those cases are directly applicable here with your concurrent jurisdiction over 1983 if you choose to get to the merits, because Mr. Mason has decided to bring this solely under the federal Constitution. The City of Daytona Beach Del Persico case, Florida Supreme Court case, holds that it's within the police power to regulate these types of things. So the city of Castleberry made legislative findings in 1467, that section of the ordinance. The legislative findings are absolutely consistent with what is required. We cited cases to you in the brief that indicate that the courts should be loath to substitute their judgment.
Focus a minute, counsel, on the O'Brien case and tell me how you think that ordinance can square with O'Brien. I have a real difficult time trying to figure out how you can square the existing ordinance and what he's attacking in that ordinance with O'Brien.
Well, very, very easily. O'Brien, first of all, by its own terms, doesn't apply when the regulation is applied only to pure criminal behavior, behavior that has no expressive component. Now, Arcara against Cloud Books, which is a more recent case, a 6-3 decision in the U.S. Supreme Court, that makes it very clear that it's not a First Amendment issue. You can't commit crimes in a business premises, wrap yourself, I think they refer to it as the diaphanous shield or cloak of the First Amendment, and shout, book, book. I would say the same thing is here. They can't allow prostitution and drug dealing, which is pervasive, and try to apply the O'Brien test. Now, as we say in our brief, even if you choose to apply O'Brien, we think we more than satisfy that. The first prong of O'Brien is that we acted within our power, that we have the constitutional power.
That's not an issue.
Yeah, that's not an issue because of Daytona Beach, Del Persico, and other cases. That sections 1492 and 1492.3, the violations and hearing provisions, further the substantial governmental interest, and we think that that's clear here, that the Supreme Court has repeatedly said, as I mentioned before, that there are adverse secondary effects commonly associated with these businesses and with a minimal evidentiary
On the
basis.
third and fourth prong.
Yes, sir. The third prong is that we are not interested in sanctioning or suppressing expression. And we have the most conduct-based ordinance imaginable. What we say is, if there are 3 or more violations in a specified period of time, and at least 3 of the violations result in a conviction with regard to drug dealing, prostitution, and beverage law violations, that the license is suspended only for 30 days. And as you know from the cases we cited that Mr. Mason is complaining about, there are many, many cases in the alcohol context that say these types of schemes are approved of.
It's the fourth prong that I'm trying to get you to.
Okay, and the fourth prong, and I kind of knew, Judge, as the case we cited, Fox, Board of Trustees, the language of the incidental burden, least restrictive means, etc. It's not a least restrictive means test. We cited to you language from Board of Trustees versus Fox, where the U.S. Supreme Court said, quote, "We have not insisted that there be no conceivable alternative, but only that the regulation not burden substantially more speech than is necessary to further the government's legitimate interests. And we have been loath to second-guess the government's judgment to that effect." Judge, all we're saying is don't have prostitution and drug dealing on your premises. As you know from the record, undercover operations disclosed pervasive drug dealing and prostitution, performance of sexual acts for money, and we cited to you cases which say that you can impute knowledge to the owner when there is such a pervasive occurrence of this type of criminal activity. And that's clearly what the ordinance is designed to prevent against. We don't want the absentee owner to essentially, from the Hogan's Heroes show, pull a Sergeant Schultz, I see nothing, know nothing. We're saying that business owners should, knowing the nature of the types of problems that can arise in these businesses, assert supervisory power. A license is a privilege. This is not a criminal sanction. The owners of Rachel's, I'm sure, have made a lot of money. The record in this case supports that, because in Rachel's, we have put into the record evidence of receipts, and there was some suggestion of money laundering with credit card vouchers. So clearly the owners have derived a substantial financial benefit from their license. It's not too much to ask that they operate their privilege in a responsible manner. And the cases say that. The cases say that it's okay to sanction a license when there is pervasive misconduct and violations. It's no different than if your honors take a look at 893.138, which is a statute in Florida allowing cities to abate nuisances, including closing premises, with far less procedural safeguards in the statute, I would submit, than what the City of CASSELBERRY ordinance provides. 561.29, authorizing the division of alcoholic beverages to mandatorily close down facilities where there are beverage law licenses, and Mr. Mason acknowledged that with his reference to 7-Eleven. This is, and in our CARA cloud books, Chief Justice Berger notes with some humor that the New York Times or some major newspaper publisher, if it has building code violations, could lose its occupational license. It can't say, I can operate my business in a fire trap because I'm publishing newspapers. Rachel's, because they're doing erotic dancing, can't allow striptease to translate into drug dealing and prostitution. And the city has a significant interest in passing an ordinance which he characterizes as crafty, we characterize as effective, to try and encourage owners to responsibly supervise their business. This is not a least restrictive means test, Your Honor, as the Fox case points out. We think we're well within what is permitted. We think that we shouldn't even have to get to that point, though, because of the law of the case doctrine. And I do want to mention that the error, if there is any error, was invited. The order was granted at the behest of Mr. Mason. I opposed it under a seldom successful futility argument on a motion to amend. And if you read the transcript granting the motion to amend the complaint, Judge Nelson makes it very clear it was not a merits decision. She was applying what she thought was her obligation to liberally allow amendments. Not a merits decision at all. Are there any other questions? If not, I believe.
Thank you, Mr. Brown.
What's the current licensure status of Rachel's?
Well, they have their license back. They were revoked for 2 years, and they're back. All that was revoked, Your Honor, was their adult entertainment license. They were free to operate as a restaurant and a bar, and I've always been informed that they have, excellent food, and we didn't close them down totally. And in fact, as I've made clear in other proceedings, they could have had attractive girls in cocktail dresses dancing seductively, much like Hooters would not be subject. There are certain specific activities that invoke the licensure requirement. They could have done many things to be profitable. They have their license back.
Thank you, counsel.
Thank you.
In the body of my time, I want to quickly address the first point that was raised by Judge Cohen, and that's regarding our current status of our license. The reason we're concerned and nervous is, yes, they've made amendments to their code. None of those amendments to the code are germane to what we're bringing here, but what they did do is they created what we call the Rachel's Amendment. And it says we got you once. If we revoke again, it goes to 5 years. Well, we're the only game in town that's ever had their license revoked, and therefore we feel like we're sort of in the crosshairs. So obviously we're concerned about this code and this happening to us again. Otherwise, they wouldn't have went to the lengths to amend the code to create additional punishments that were never there.
Is there amendment to the code moot any of your legal arguments?
No, they never raised in front of Judge Nelson. It's identical. You can compare the code in 2001 to the code now. Identical. There was a typo. They had the Arabic 3 about suspension and revocations twice. They made it 3 and 4. Absolutely nothing that would remotely amend this. The issue of our care of books. What happened with the Supreme Court and our care of books was there was a body of federal law where nightclubs were coming in and saying, you can't revoke our license because the effect of that, the net effect would be to close and stop striptease. We're cloaked in the shield of the First Amendment. You can never close us down based upon that. And the Supreme Court said, no, that's not a prior restraint. You're going to be treated just like...
Well, their ordinance, though, is directed to closing you down because of prostitution, drug dealing, and possibly money laundering or whatever it was that they were concerned about.
Yes, and so post our care, all the cases I've cited said, yes, you can revoke the license, but they're entitled to fair process, just like the 7-Eleven. The cases I'm citing are process. So he wants to graft the big theory and eliminate process and say we can revoke and we don't have to have any process. And the cases I'm citing are right up until the present day. There's nothing that says you can revoke a license, whether it be the pick and save license, the local tavern, or a go-go bar based on strict liability. Our care has nothing to do with this case. And finally, just very quickly, I'm actually talking to Judge Griffin, I think, in large part. Judge Griffin, you said paragraph 31 in the former complaint was alive and well. Revocation order does not further a substantial government interest, does not constitute the least restrictive means to achieve the city's goal, and thus same violates Article 1, Sections 4 and 9 of the Florida Constitution and Florida law. Article 1, Section 4 is the parallel of the First Amendment. The Florida Supreme Court has said again and again and again, it's identical to the First Amendment. You have no greater ambit of protection, just like Article 1, Section 9. You then look at our new complaint, paragraph 16, paragraph 11, 1492, 1493 violate the test set forth in United States O'Brien, 1968, which is that language I stole right from the case. And then paragraph 16, which is somewhat redundant, says revocation order in sections 1492, 1493 do not further a substantial government interest, do not constitute the least restrictive means to achieve the city's goal and thus violate the First and 14th Amendment.
Didn't those claims have been brought initially?
They were brought, but we've never had a merits decision on them.
No, they weren't brought. You brought them initially as a Florida constitutional issue, and now you're raising them as a United States constitutional issue.
Yes.
Couldn't you have raised those initially?
Yeah, I think we probably could have. I mean, if I'm wrong on this, and I don't think I am, you know, and I still would request supplemental briefing on that case, but if I'm wrong on that, it would just seem like the worst thing that would happen to us is that we would go back under the Florida Constitution, right back where we started from when you remanded, and I'd get to litigate paragraph 31, the revocation order does not further substantial government interest is not the least restrictive means. Then I would win on the merits. The problem is we wouldn't get attorney's fees, we wouldn't get damages, but we'd get rid of this terrible code that's scaring us to death. But we'd be right back where you remanded us without the amendment. Now, I hope that doesn't happen, but as an alternative argument.
Well, you could have preserved that right if you had added these federal claims as well as continue with your state claims, couldn't you?
My head is a buzz. I think the answer is yes.
You made the decision to abandon the state claims and proceed with the federal claims, correct?
Based upon a court order.
Well, you didn't have to abandon the state claims, did you? Am I missing something?
No, but the reason we did that, if you want to know the answer, is the Florida Constitution is not self-affecting. You don't get attorney's fees or damages. You got to have a procedural mechanism. So
But you could have gotten your declaratory judgment.
Right. So the worst thing that should happen to us is we got to go back to square one. We shouldn't lose everything.
And you would go back to square one if you had preserved those claims.
Judge, all I can say is, I mean, I don't even think it's a nuance here. I mean, in this case, I mean, looking at what happens to us, and it sounds, I mean, I can't read your minds, but it sort of sounds like you're probably inclined to agree with us on the merits, but then you have these procedural issues, and then we have a judge who grants us this amendment, and we have this argument's never raised until the day of oral argument. It just seems like there's just something not right about that, and that's why, at a minimum, it seems we ought to get some supplemental briefing and air this out better, because he said
As I explained to you before, it seems to me that the Don Suntan case is nothing more than an expression of what the law already is, and the law has been fully briefed on the question of law of the case and res judicata. And the decision was made, for whatever reason, not to pursue these. I mean, you came up here and you said we really need to get a deck action on these state constitutional claims. We need a declaration that this is a violation of the state constitution. And whether we were right or wrong, Mr. Brown maintains that we were wrong to do that. We said, okay, go back and pursue your state constitutional claims. And you made the decision not to, and apparently had a good strategic reason for doing it.
That seems to me, and I'm not you know, trying to throw stones, but it just seems to me that is extremely form over substance. I mean, there's no doubt in my mind if I said to you, Judge Griffin, I'd like to have leave to amend, and I cited this whole body of cases, you'd say, yes, you're entitled to amend practically through the entire case, and you're going to remand it, starts over. You would have done that. Judge Griffin, I mean, Judge Nelson did that. He argues that the whole point of their code is to encourage owners to take responsibility. And the cases I've cited to you say you don't achieve that means if you're going to punish Jim Weigel, who's in the audience, for something his workers do without any connection to him, and that's what your code provides. If you're trying to make someone be a good steward, you know, and not have something that's so overly broad just to be punitive without really assuring compliance with the law, is you'd say, hey, you got to be a good steward, here's the standard, but not strict liability.
And surely you understand that there are other issues that are involved as well, one of which is that when you litigate a case and you lose it, and you take an appeal and you lose it, you don't come back and say, oh, I've got a whole new plan. I've got more theories, things I didn't think of before, or things that I decided I'd bring in federal court, or things that I decided I wanted to do later. Let's just do this again. Because the courts don't let you keep doing it and doing it and doing it. You come up on appeal, you preserve the claims that you've got, and then you go back and you litigate those claims. You don't get to keep raising new claims after you've come up on appeal. And the law that you cited to the trial judge that convinced her to allow the amendment is law that doesn't apply at the appellate level. It's the wrong law.
If the point is those cases stand for the proposition we want to reach the merits, I mean, that's the bedrock that goes on again and again and again. How would that be any different whether I'm asking Judge Boyce for amendment or Judge Nelson? But putting that aside, you said I raised a different theory. Well, what I raised was a different procedural vehicle, but it's the identical theory. It does not further a substantial government interest, does not constitute the least restrictive means. The amended complaint says does not further a substantial government interest, does not constitute the least restrictive means. I don't see that as a new theory. That's the same theory. I'm just raising a different procedural vehicle because I want attorney's fees and damages for my client, not just getting the code knocked out. You know, I want a bigger hog rather than a smaller hog. But the theory is the same, Judge. I mean, if it's Article 1, Section 4 is identical to the First Amendment and a substantial government interest does not constitute least restrictive means, how can that be a different theory?
And why didn't you raise your claim for the bigger hog to begin with? There's no reason not to have raised the bigger hog claim to begin with.
Well, Judge
It
Nelson,
wasn't like the federal Constitution was a mystery. Most of these claims, with the exception of the few that we parsed out, had been raised in the certiorari action and disposed of.
but people do that every day in front of trial judges. They come back and they go, I'm amending my complaint. I mean, it happens constantly, Judge. I mean, there's nothing novel about that.
Counsel, your time has expired. Thank you. We'll be in recess.